A jury is deliberating the fate of a mother accused of fatally leaving her baby in a hot car during her spa appointment. Plus, a trial date is set in the case of a Georgia teen charged with killing her parents. But we're learning there are social media posts the defense wants to keep out first. And celebrity attorney Alan Jackson now representing the son accused in the death of actor-director Rob Reiner. The court of law has wrapped up for the day in those cases. Now it's time for Court of Opinion. Welcome to Court of Opinion. I'm Jenaé. Thank you for being with us this hour for something a little different here at Court TV. We know in a court of law, it's all about the law and the facts. This hour, we've got a fantastic panel for you, and they'll let their opinions run free, all based on the most pivotal facts in the cases that we are tracking across the country. Let's quickly get to our first case, where right now a California jury is pouring through the evidence in the trial for Maya Hernandez. She's charged with second-degree murder after leaving her children in a hot car while she was at a med spa cosmetic filler appointment. Her 2-year-old survived, but her 1-year-old did not. This case has been unique for us because cameras were not allowed inside of this courtroom for testimony, only for the openings and the closings today. And in case you missed it, here are the highlights from closing arguments.
We are here because on June 29th, 2025, the defendant, the biological mother of Emilio and Mateo, chose herself. She chose herself at the expense of her children. She chose herself at the expense of Emilio's life. We are here because on June 29th, 2025, the defendant chose her looks. She chose to make an appointment in Bakersfield, a cosmetic procedure. In her words, a procedure to make her feel more beautiful. The choice for her to feel more beautiful, to focus on herself, to focus on her looks, killed Emilio. What was happening to Emilio as she sat in the building and ignored her responsibilities? He was burning from the inside out. His body was rising to temperatures that are not compatible with life. After the defendant's procedure, the defendant left the building and went outside. Shortly after, a few minutes later, the defendant came in carrying Emilio. Emilio, who was completely limp, turning colors. This case is not about accidents or mistakes. The defendant did not accidentally leave her children in the car. She did not forget they were there. The defendant purposefully, willfully, and intentionally left her children in the car. And she did so knowing what could happen.
Maya was criminally negligent. That much is clear. Her behavior was absolutely more than ordinary carelessness, inattention, or mistaken judgment. She was reckless in a way that created a high risk of death, or GBI, and a reasonable person would have known that acting in that way would create such a risk. That's why this is involuntary manslaughter and child endangerment. Conscious disregard is missing because Maya thought the air conditioner would stay on. Maya left the AC on and the fob under the seat. She was conscious of the heat and did the opposite of disregarding. That's why Maya left the AC on in the first place. I'm asking you to find Maya Hernandez not guilty of count 1. Her conduct was clearly criminally negligent, but there is no implied malice in this case, and this is definitely not second-degree murder.
Ladies and gentlemen, you just heard a lot from Mr. Wakeman about not checking on her kids, being criminally negligent, essentially being a bad mom. You heard that she thought the air conditioner would stay on. She thought it would stay on, therefore she's not guilty of murder. But again, what you never heard is she knew it would stay on. 2.5 hours without checking on her children who were in a car. Ladies and gentlemen, had the defendant, Emilio and Mateo's mother, given her children so much thought that day as to go check on them once every 30 minutes, we would not be here today.
A lot of passion there from the attorneys giving those closings. And again, this jury has had the case for an hour and 32 minutes out there in California. Let's bring in our power panel. We have in studio with us tonight criminal defense and civil attorney and former judge Jesse Law is with us. We also have criminal defense attorney and law professor at Emory University and former federal defender Molly Palmer. And also joining us remotely, we have clinical and forensic psychologist and author Dr. Leslie Dobson. So great to have you all here. Jesse Law, let me start with you. My question, when you're hearing that passion from the prosecutor, this is a case that really can bring some outrage in those jurors if they are watching this. What's your opinion on it?
I think it's pretty clear there's going to be a lot of outrage. I mean, whether it is a little baby in the car or whether it's even a little puppy dog, you are going to bring those feelings straight out of individuals. And the first thing they're going to, when they hear the prosecutor, they're already on the prosecutor's side. They're going to have outrage. They're going to be looking at the defendant as if she's some kind of monster. And they'll probably be hoping that they not only get to decide guilt or innocence, but they also want to be participating in the sentencing phase. Because no punishment can ever be enough for someone who let a little baby die, a little innocent child, or even a little puppy. I mean, when I see those things, I get outraged when I walk by a car and see that. I mean, I really don't care. But that's going to be the initial reaction in that jury when they hear that. And the defense counsel is going to have such an uphill battle to tone down that passion, to tone down that anger, and to tone down that defiance and to try to portray his client as a very young, immature person who simply didn't know what she was doing. And that's a tough fight.
Molly, you had an interesting opinion on this one, that it may be different if she had a different kind of appointment and she was a single father, not a single mother.
Absolutely. I mean, this is what the law is actually about. If you're a practicing trial lawyer, you know, we say, okay, well, is this negligence? Is this a mistake? Or is there some intentionality behind this? And those are, I guess, the legal questions. And the statute would apply the same, whether it was a young man or a young woman, a single mother or a single father. But I think if you're a smart lawyer, what you have to counter here when it comes to saying this is an accident or this is a mistake is this idea of, well, those things we can forgive, right? A jury in this case is going to have such a more difficult time forgiving somebody who leaves children in the car, not for a medical appointment to pick up a prescription, to go to the grocery store, to do something along those lines, but to do something that society sees as vain and unnecessary. The statute doesn't contemplate what you're doing. It doesn't say if you leave the kids in the car for this long and go here versus there, that's what you should consider, but I guarantee that is what is being considered more than anything else.
And the prosecution spent a lot of time with that buzzword, vanity. She did this over vanity. She cared about that more than her children. Let's bring Dr. Leslie Dobson into the conversation. When you're looking at this, I know you assess people all the time as a behavioral specialist. What do you see? What stands out to you about this defendant in this situation?
It's not just that she went in for lip filler, which I have it. It's about 20 minutes. It's the additional butt lift that she got. It's the timing. It's the planning. It's the not using her sister for babysitting. But for me, it's the additional factor of I know exactly where she went, and it's a very dangerous area. I would not leave my children in the car because it's dangerous. And she left them in an unlocked car. There are so many elements of carelessness to the safety of those children, not just the temperature and not just her vanity.
That's very true. And that's something that she was actually questioned about on the stand, whether or not she even thought about the other factors that could have been a problem, because she did think that the AC was running. I want to play a soundbite from Ian Blue. He's someone who was interviewed by the media there in Bakersfield, California, after this happened. He was actually in that medical spa at the same time. He remembers seeing her. Here's what he said about this incident.
Maya was like, oh, I have 2 kids. But she never mentioned that she had him on the car. She never, ever she was never like, hey, let me go watch let me go get my kids, you know, or something. Like, she had the chance. I heard that she was saying that her car was on and the air was on and that the windows were open. That's a lie, because I was there, that I know the windows were closed for sure, and I know the car was off for sure.
Judge Law, is it any different than someone who may have simply forgot? I mean, that does happen. We see parents on trial who say they were distracted by video games, or they went to work and didn't realize they didn't drop off their child at daycare. Is this very different?
This is very different because this was a woman who purposely parked in that location for an appointment. She didn't have an appointment to go to a grocery store. She didn't have an appointment to go to a daycare. She didn't have an appointment to go to a job. This was a scheduled visit. And I believe that she was in the waiting room for a significant period of time.
2.5 hours.
Before her procedure. Time that she could have spent instead by just simply leaving her cell phone number with the receptionist, saying, I'm going to sit out with my kids. And then, you know, she had a spectrum of choices. And this is a situation where the fact pattern is just going to work so harshly against the defendant. The fact pattern doesn't help her in either way. This is a selfish, vain reason. She is doing it simply because she's trying to beautify herself. She isn't running into a pharmacist to get medication for the kids or for herself, or standing in line to get food stamps, or, you know, doing work in order to get money so she could feed her kids. This is something that's very vain, very, very horrible. You know,
these jurors, they are weighing that right now. Molly, one of the things that they're not weighing, potentially, I mean, unless they ignore everything they heard in closing arguments, they're not weighing not guilty, because the defense says, yes, we want you to hold her accountable, but that this is not second-degree murder. This is involuntary manslaughter. What's your opinion on their approach? Because that's sometimes a risk.
Oh, absolutely. But, you know, it gave me insight into probably what happened leading up to this trial as it relates to plea negotiations. And as a criminal defense lawyer, a former public defender, there are situations where there's no plea. You know, you try and negotiate, there's nothing you can do, and you have to take it to trial because, first of all, that's the client's choice. And I imagine this is a situation where there is no offer on the table, and that's why during the course of the trial and in argument, you hear the defense conceding. You think, why are you going to trial if you're just going to say she's guilty of this? Because there was nothing on the table for them to resolve the case to, and you have to go to trial. And so then you stand up in front of a jury and you try and use that somewhat to your advantage and say, look, we're admitting to what we did, but here's what we didn't do and here's why. And so, you know, what the defense did in putting her on the stand and trying to tell her life story and about how, you know, her ex was in jail for domestic abuse and trying to do all of that, that was the only strategy that they had. But there are reasons that defense lawyers go to trial, not simply to just win, to just get a slam dunk not guilty. It's a far more complex process than I think a lot of people realize.
That is interesting insight when it comes to what happens behind closed doors before we get to a trial. Dr. Dobson, I want to get your take on this. I actually want to play something from her public defender, who was asked questions before this trial started, and he's talking about what he thinks is a real mitigator in this case.
There's a human need to protect children and to care for children, but the fact of the matter is she's still a child herself. She's barely 20. You don't stop becoming a child when you turn 18.
Dr. Dobson, what's your opinion on that? The age of this young mother who had 2 kids. She had a toddler who was 2 years old and a 1-year-old, and she said on the stand she had no idea the car would turn off, and she didn't think about any of the other problems that would happen.
But she thought about the cost of lip filler and butt filler, and she put herself on a payment plan to pay for that. As a single mom, you'd think she'd save that money to help care for her children in the future. She shows her IQ is too high. She is too aware of too many things to be unaware of this. It doesn't make sense, and it doesn't align.
What do you think if the jury is weighing, Dr. Dobson, to follow up with you, for jurors, if they're looking at this case and they're wondering whether or not this should be something to the level of second-degree murder or involuntary manslaughter, what do you think the feelings about hot cars and the push that there is publicly that we want to make sure people know, don't do it. It is the worst decision. Find another option. Do you think they'll be wanting to send a message with a case like this?
Definitely. And I think it's, as a jury of her peers and in that area and in that population, a large amount of farmers, a lot of poverty, a lot of gang, a lot of crime activity, I think people are going to look at this and say, you are so selfish. You should be lucky that you have two beautiful babies and you are choosing to puff up your lips. And, she appears to be sitting there kind of trying to suck them back in and look like hell, but you can't hide the puffy lips sitting there on the stand. She looks like she is vain, and then they are acting like she looks worse, like when Sean Combs wore his cardigans every day. It didn't fly.
Thank you all for your opinions on this one. Again, the clock is still ticking there. Hour and 42 minutes. This jury has it. If they come back with a verdict, we will break in and bring it to you live there out in Bakersfield, California. We have to get to our break, but when we come back, we're going to take a look at a decades-old evidence that's shown in court today. This is in the drowned wife murder trial for Paul Hicks, and that evidence, it included divorce papers that he filed on a suspicious date. And we'll have our pick for today's best evidence next.
Tonight on Closing Arguments, a deadly shooting at Brown University and a killer at large. Court TV's Matt Johnson is on the ground with the very latest.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
A Microsoft executive gunned down. Now his ex and her new husband are charged with his murder.
A social media sensation, now a suspected killer.
She wrote a children's book about her husband's death. Now she's accused of killing him.
Welcome back to Court of Opinion. Let's go beyond the gavel. We are following a once cold case in Ohio where a husband was the prime person of interest, but there were no charges in his case until 24 years passed. This is the drowning death of his wife, Regina. Paul Hicks was charged after his close friend came forward to say he wants to tell the truth about what he really witnessed back in 2001. This is a man, Stephen Gates. He's expected to testify tomorrow. Everything hangs on his testimony. And he's expected to say that Paul pushed his wife's unconscious body in a vehicle into a pond. Now, this is a trial that can be tricky because the evidence is all over 2 decades old. And today, the jury saw some difficult photos of the victim. Here's what our Court of Opinion team chose as the best physical evidence presented for trial day 5. This photo of Regina Hicks's body in the car pulled from that pond. And the important thing that the investigator wanted to draw out is that she was located mainly on the passenger side, but seemed to be slumped a little bit over the console that was in the middle. Let's bring in our power panel to see what they think about images like this shown to the jury. We have with us Jesse Law, Molly Palmer, and Dr. Leslie Dobson. Molly, let me start with you. Seeing that, the passenger side of someone who's inside of a pond, how does it move the needle, in your opinion, when she could have moved inside of that vehicle, but the prosecution wants to say she's in that passenger side because he was on the driver's side?
I mean, I think it's interesting because, you have a situation where, like you just referenced, there's so much time elapsed, and the jury is going to be grappling with that, right? They're going to want to know, why is there a delay here in terms of this individual being indicted and charged? And this is evidence that, would not change over the course of 20 years, right? This is not a situation where we have an advancement in DNA technology, and now we can say, oh, scientifically speaking, we're at a different point in the modern era where now we know. This has remained the same, right? But it's also the kind of thing where it is arguably very compelling evidence. It is very compelling evidence. And things like photographs, juries love photographs. They latch onto this much more so than testimony usually at trials.
Judge Law, what do you think?
Well, I think that gives a lot of room for the defense to argue a good, reasonable doubt as to why that body is in the rear seat. I mean, the body was submerged. There doesn't seem to be some kind of restraint over the body, like a seatbelt or something. It is possible for the defense to argue, and if they can bring in an expert to explain to the jury what happens to a human body, a corpse once it's underwater and submerged, there's a very good argument that the body could have floated and relocated. And it would be very hard for the prosecution to say, yes, she was definitely in the passenger seat at that time. I think there's a lot of room for a defense to argue there.
I'm going to bring in Dr. Dobson to ask her about something. Molly Palmer mentioned that things could have changed in 25 years. And I want to ask you about the change perhaps in sentiment. This case back 24 years ago, they had basically everything in terms of the past between these two, the alleged domestic violence at his hands against his wife, the issue where she was wanting to leave him, the dangerousness of that situation, but it did not lead to charges. Do you think the sentiment has changed 25 years later to where they were very ready to accept the testimony that we are going to hear from this friend?
I think the field of psychological assessment and lie detection has significantly advanced. If you let me in a room with this guy, give me 20 hours, let me do every test I want on him, I can tell you if his answers are consistent, if they're frequent, I can tell you if he's lying. I can tell you what he's telling that is true, as well as the man who is wanting immunity to come forward. But we have advancements where our normative samples are so vast, the analytics are significant, and you can't beat the test anymore. And we didn't have that 20 years ago.
That's a good point. There was even an attempt at a polygraph test in this case. But I do want to get to something else that we saw that was really compelling evidence that came out today. This is a copy of the divorce papers filed by the defendant, Paul Hicks, on October 19, 2001. And why that's important is this is the day after Regina was last seen alive by her boyfriend. She was leaving his home. Now, these two were allegedly estranged, but they were together in a sense in terms of their marriage. But he filed these papers right after she was missing, and so that would be before her body was pulled from that pond. And another note that came out in court today is that he claimed to police that they were living together when apparently that was untrue, that he was living with his parents at the time. What do you think about the divorce filing, Molly? Is that something that can move the needle? Or if they were already estranged, does that really mean anything? It's just a coincidence?
It really depends on your jury, but I do think in general, juries are always going to consider motive. And if you don't have anything that could conceivably be a motive, you have a problem as the prosecution. And so it's not so much whether these divorce papers were in fact the motive. Who knows what the dynamic was here, right? This is, again, a long time ago. These are interpersonal relationships. We can only speculate. But if you have something that can create the idea that maybe there's a motive, then all you need is one or two jurors to latch onto that and start that conversation back in the deliberation room for it to actually kind of catch fire and go somewhere for the prosecution.
Judge Law, why would he be filing it the day after?
Two things come up for me. First of all, okay, as the defense, I'm going to argue, so what? If he was estranged, he may have been hanging on to those divorce papers for a while when he had been living with her, when he filled out those papers. And then things worked out that he said, no, I'm done with you. And he moved out and moved in with mom and dad. But he still had those papers. He didn't revise them. And then he filed them. And the fact that he filed a divorce indicates that he wants to do, he wants to be separated with her. He doesn't want to be with her anymore. Where's the motive to kill her? He's taking steps to move away from her. So I think that divorce motive can work, for the prosecution or against the prosecution. And I've seen lots of divorce filings where the fact pattern they've set forth in their pleadings don't necessarily match when they file the paperwork. So the fact that he lives separately from her at the time that he filed it may not be to his veracity, just to the way things happened.
Could be the argument that we will hear from the defense. They reserved their opening statement, so we don't know really what their theory of the case is. Dr. Dobson, they may call to the stand someone like you with your expertise. What's your take on this relationship between the two? Because there's this allegation of not only them being estranged, but that there may have been abuse there. And this can be a very dangerous time for a partner when they are separating from a relationship.
Definitely. I think we need to know if he has narcissism, if he's psychopathic. Did he have a fleeting mood disorder, psychosis, depression? We need to know, because however he was 20 years ago, he likely still is today. And with those diagnoses comes a desire for vengeance and harm and callousness and a true desire to end a life or hurt a woman who might have hurt him in some way, that narcissistic wound. So I think the psychological aspect of him, his collateral information, people he's been with and known over the 20 years, I think it's brilliant. We have so much more information that we can get rather than a case that is more recent. So it will be a beautiful 100-page report probably from a psychologist just dictating what this man's mind is and the likelihood that he did something out of vengeance.
Dr. Dobson bringing up something that would be the rare benefit of a cold case here. Talk about that. I mean, there's so much that's usually lost when you have 24 years in between the incident and when a jury gets a case.
Right, and I think that kind of develops a little bit of skepticism. You're dealing with a jury, you know, like we talked about with the first case, the jury kind of is already hearing the facts about a dead child, and it's really hard to pull them over. I think when you start with a cold case, the jury essentially is like, well, how, you know, why did it take so long to get in our hands? Why did it take so long to be here in front of the jury asking us for a verdict? Was there reasons why this shouldn't have been brought? And what were those reasons? And so, you know, a lot of questions are going to be unanswered during the course of this trial, and it's very difficult, I think, for a jury to convict beyond a reasonable doubt if they go back there and start asking those questions as to the temporal remoteness of the investigation and decision-making and everything else that has happened in the course of the quarter century, that this man was just free.
Oh, absolutely. Tomorrow's going to be a huge day inside of that courtroom. We have to leave it there, but again, that key witness, Stephen Gates, he is expected to testify tomorrow. You can watch that, of course, on Court TV Live. Up next, we're going to go beyond the gavel for a pending case of a teenager accused of shooting her mother and stepfather as they slept. She made an appearance in court today, and we'll discuss what has to happen before her trial starts next month. Every day here at Court TV, we see the judicial process play out in courtrooms across the country, from jury selection to the presentation of evidence, all the way to the verdict and sentencing. But what happens before a case makes it to court and after a case is adjudicated? That's what lies beyond the gavel. And we're taking you now to Georgia, where an alleged parent killer, Sarah Grace Patrick, was back in court today for a calendar call. She's a 17-year-old who's accused of killing her mother and stepfather, Kristen and James Brock, who can be seen in this image that was posted to Daniel Patrick's Facebook back in February. And here's a recap of this case. Investigators say the parents were shot to death while they slept. Patrick called 911. She reported the deaths and went on to post on TikTok about it. She was arrested in July and charged with 2 counts of aggravated assault and 2 counts of murder. And here's what happened in court today. Both sides say they are ready to go to trial in less than a month. January 5th is the trial date. There's also a pending evaluation report from a defense neuropsychologist that could throw a wrench in things when it comes out. The state says that they have to see it and see if there may be something that will impact the timeline. Let's bring in our power panel in studio. We have criminal defense attorney Jesse Law, criminal defense attorney, and former federal defender Molly Palmer with us. And joining us remotely, we have clinical and forensic psychologist and author Dr. Leslie Dobson. Dr. Dobson, let me start with you on this one, because we've got a situation where she's a 17-year-old being tried as an adult for the death of her parents. What's your opinion on cases like this one?
This is an interesting case of parricide, and in particular because you bring up social media. There was a lot of social media that was found in this case, and a lot related to substance use and trauma and abuse in the home. And so for me, a case like this shows me that this was a call for help, and no one was helping her, so she took it amongst herself to end their lives. That is what I would assume, and she may have also done it to rescue her 6-year-old child, or her 6-year-old sister, who came upon the bodies before she called 911.
Molly Palmer, react to that for me, and also the fact that we're going to trial January 5th. This is only about 6 months since she's been arrested.
Right. I mean, sometimes strategically, one side or the other wants to have more of a speedy trial than would be the alternative. But I do think there is more to be seen. My sense is that we are going to see some sort of defense that really highlights whatever trauma or abuse or negligence this teenager was suffering and kind of spins it in a way that maybe at this point we haven't seen much of, right? We've heard the facts about how she callously took to social media after the killings and how she put her younger sister in a situation where she came up on the bodies. I mean, all of these horrible, horrible facts. But I have a sense that this is going to be one of those trials where there are additional horrible facts as to the accused, as to the defendant, that we have no idea the depths of just yet.
Well, we're going to talk about some of those, but you mentioned her taking to social media. So I do want to share that because it did become a huge point of contention, especially early on in this investigation. Now, these were posted to the TikTok page of Sarah Grace Patrick, one that came with the handle sgrace0482. Let's take a look. This happened just after the murders of her parents.
He doesn't know it, but a year from now, our family will be torn apart, and I will move far away and won't see or talk to him for 5 years. I'm feeling so
Jesse Lal, I don't know how a jury will react if that comes in as evidence. What's your opinion on it?
I really don't know how to react myself. I mean, it showed a family, it showed her crying. It didn't really point to any kind of issues of abuse or domestic violence. It just showed a regular family, and then it showed the defendant crying. I mean, and then there was a comment that they're going to be torn apart. Is that some kind of doomsayer saying that she plans to kill him? Is that how they're going to be torn? I mean, there's a lot of implication in there without any readable conclusions. This is a trial. If the state is ready to go to trial with this, they better have a lot more solid, tangible evidence to lead the jury to believe that she could be convicted of murder beyond a reasonable doubt. If they're relying on her callous attitude, I mean, there is a lot of room for the defense to argue that this is a very young girl who was just engaging in conduct that most young girls engage in. I mean, the fact that they use TikTok or Instagram or whatever social media in there is not necessarily because they are trying to show how callous and insensitive and unfeeling they are. This is just their second nature.
Dr. Dobson, can you weigh in on that?
I think definitely. I mean, I think we have to also focus on the criminal history of the parents. There's a known history on the record that they had abuse claims against them and substance abuse claims. So I don't think we can take what this girl was posting on social media seriously and as anything necessarily factual, but it shows me that it is a young girl in an abusive environment, distressed, shouting out for help and not getting the help that she needs.
Molly, I want to get your take on this because Dr. Dobson's talking about something that may be kept out. The background of the victims, maybe even the background of the defendant, because we do have this latest motion in limine that was filed by the defense. I want to put it up on the screen. This is the defense trying to keep certain evidence out at trial. In particular, all videos, posts, or pictures depicting or alluding to sexual behavior of the defendant, meaning the 17-year-old in this case, and any comments related to illicit drug use or hiding drug paraphernalia. They say this information is irrelevant to a determination on guilt or innocence on the charged offense. Do you think the judge is going to allow that in or keep it out as it relates to perhaps what the tension was between this parent and their child?
Well, this type of motion is supposed to be decided on a case-by-case basis, right? And so the judge is going to have to weigh a few different factors and consider it under what we call the totality of the circumstances. But this is a routine thing that good defense lawyers do because the idea is this. Juries are supposed to decide a case based on the elements and the burden of the prosecution. But what happens, as you know, we see all the time, is that we develop certain, I don't know, kind of visceral reactions to the defendant. And it has nothing to do with the elements of the crime. It has nothing to do with the evidence as it relates to murder. It has to do with the fact that maybe she was a promiscuous teenager who used drugs. And now we think, oh, it's not so much that there's proof that she killed these people, but there's proof that she's a bad kid and we don't like that. And so, you know, I think it's always a good idea idea for the defense to not only file this, but for judges to err on the side of not allowing this type of evidence to come in. And oftentimes, if this evidence does come in at the trial court level, this is exactly the kind of thing that gets reversed on appeal.
Jesse, I see you shaking your head.
Well, it's true. I agree with Molly that the judge could err on the side of caution and not let the evidence in. But the beauty of a motion in limine is that it's not the be-all and end-all. Just because there is, as we said, we don't know what the defense intends to introduce. And there is a possibility that the defense will always ask the judge to revisit the motion. And if there's evidence in there that shows that such evidence could be relevant to either a defense or to a point being made, or something that the prosecutor inevitably let out during cross-examination, yeah, the judge can always revisit and let the evidence in. So it's a real tough call to say just because the judge is going to rule it out at the beginning. I mean, I've seen trials where they've come in during the course of mid-trial and changed the tune or changed the tenor of the whole course.
Oh, absolutely, and that trial is nearing. January 5th, again, is the date that they are set to trial. Both sides saying that they are ready to go forward. That neuropsychologist report's still pending, so we'll bring you the updates here on Court TV. We've got to get to a break, but coming up, we've got our hot takes and cold facts. Our panel giving us their opinions on today's biggest cases, including Rob Reiner's son, who now shares an attorney with Karen Reed, 2 men sentenced for a hit and run, and a doctor who played a role in the death of beloved actor Matthew Perry. Stay with us. We'll get into all of it next.
Tonight on Closing Arguments, a deadly shooting at Brown University and a killer at large. Court TV's Matt Johnson is on the ground with the very latest.
Closing Arguments with Vinny Politan, tonight at 8, 7 Central, only on Court TV.
The Microsoft executive gunned down. Now his ex and her new husband are charged with his murder.
A social media sensation, now a suspected killer.
She wrote a children's book about her husband's death. Now she's accused of killing him.
Welcome back to Court of Opinion. It's time to get the hot takes on the cold facts, on the big legal headlines we are following here at Court TV. We have our power panel giving their strongest opinions and takes on these cases. And because we want to get to all of them and hear from everyone, we are giving them just 25 seconds to respond and make their arguments. Let's get to our first case. This one out of California. Famed Karen Reed attorney Alan Jackson, he is representing Nick Reiner. We learned that today. This is after his arrest and the killing of his parents, Rob and Michelle. Now, Nick was supposed to be in court today, but Alan Jackson said he wouldn't be for medical reasons. Prosecutors are charging Rob Reiner's son, Nick, with 2 counts of murder in the killing of his parents. Let's bring back in our panel to get their take on this news. They each have 25 seconds rather, again, on the clock. We have Jesse Lal, Molly Palmer, and Dr. Leslie Dobson. Former Judge Lal, let's start with you. 25 seconds. What's your take on Alan Jackson now taking the reins on this huge case?
This is Hollywood celebrity, and what else would you have to represent the son of Rob Reiner? Is also another Hollywood celebrity attorney, and he's made his reputation with representing other celebrity cases. So it is most obvious that he should be out there. He has the power, he has the connections, he has the public persuasion that he should definitely represent him.
All right, that's time. Molly Palmer, you have a different take on Alan Jackson being on this case.
I do. I am. So on one hand, I think he probably has the client management skills that are going to serve him well representing somebody like Nick Reiner, who I'm just guessing might be a difficult client. But I think if you go in front of a jury and you already have this privileged son of Hollywood who now has this high profile, expensive, famous lawyer, I don't think that's a good look.
Think it's not going to bode well with the jury. Let's turn to Dr. Leslie Dobson. Dr. Dobson, we've got a lot of questions that people have about the mental health status of this individual, his addiction in the past. What's your take on this case?
Well, I think the lawyer's already doing his job fairly well. I mean, I would imagine the individual is likely detoxing. And we're not talking about a medical leave or he doesn't have a cold. There's a reason we don't know if he's competent. There's a reason he didn't show up today. And additionally, I think, this is a very expensive attorney. Who's paying for it? Who is siding with Nick? Who wants to help Nick? And I really would like to know those two answers.
Oh, that's a really interesting question, especially since we know in the Karen Reed trial, apparently he did not take a fee. Let's move to hot take number 2. 2 men sentenced to prison after pleading guilty to killing a bicyclist in an incident that was caught on camera. They were both teenagers in 2023 when this happened, stole a car, and then intentionally hit the cyclist, who was a law enforcement officer. They captured the whole thing on video, posted it to social media. 20-year-old Jesus Ayala will be serving 20 years to life, and 18-year-old Jasmine Keys is going to be serving 18 years to life in this plea. Jesse Law, I'm going to start with you. Your take on the outcome in this case.
It is going to be a sad and tragic end for these 2 young men. When you have photographic video evidence like this is what juries love, and that was typically will take the jury over the threshold to convict them, and their lives will be pretty much set in prison. Then there will be no childhood, no young boys, no young adulthood. This will be life served in incarceration, and they will come out very brutal.
So sounds like you're saying it's good that they pleaded in this case. Molly Palmer, what's your take on this one?
I think this case really highlights something that I struggle with as somebody who did focus on juvenile defense for a while in my career. You know, the idea is that if your brain is still developing, if you're a teenager, you're different. You may be less culpable in certain respects, and we should have leniency. But I struggle because when you have the role of social media with a modern teenager, it changes things, and I think it has created tragic situations like this one.
Yeah, them posting to social media did not help in the court of public opinion or in the court of law. Dr. Leslie Dobson, let me get your take on this one. You got a 16-year-old and an 18-year-old at the time, now basically serving up to life.
They're going to get out in, 20 years? They'll be younger than I am. So I don't think what they're doing, what they could serve is at all what they deserve. I mean, they pointed an officer out who has devoted his career to protecting this community, and they said on social media that they wanted to run over him. They said hit his ass. They deserve more time in prison. They intentionally harmed this man.
All right, speaking of amount of time served, let's get to our third story. The doctor who helped sell ketamine to actor Matthew Perry before his overdose death avoids prison time. Dr. Mark Chavez was sentenced to 8 months of home confinement. He is the one who gave the ketamine to Dr. Salvador Plasencia, who was sentenced to 2.5 years in prison earlier this month for selling it to Perry in the months leading up to his death. Now, Chavez's attorney says he accepted responsibility early by cooperating with investigators and voluntarily giving up his medical license ahead of his detention hearing. Dr. Dobson, I'm going to circle back to you and get your take on the outcome in that case with this doctor.
So this doctor gave the medicine to another doctor who said, oh, I wonder how much Matthew Perry is going to pay for this. How much can we get out of this guy? They need to be sentenced more. I feel like we're setting a precedent for doctors to be able to take advantage of clients, especially wealthy clients, and give them any medicine that they want because they're going to make a lot of money off it. I don't like how this played out.
Jesse Law, your take?
Well, you know, the prosecutors have to take what they can get. And if they had a key witness who was cooperating with them and was also culpable in the pattern that led to Matthew Perry's death, I think the sentencing fitted the situation. They got some help from him, but he was also culpable to a degree.
And Molly Palmer, final thoughts on this one?
Well, you know, this is a federal case, and so it's supposed to be standardized under the United States federal sentencing guidelines, and you do get a measurable benefit when you cooperate. Everyone knows that. The feds are going to immediately find somebody and sit down with them and say, hey, you want to help yourself out? Tell us everything you want, everything you know, implicate someone else. But it always surprises me, despite the purported standardization of these guidelines, that these white-collar offenders seem to have far greater leniency than others.
That's our time. Molly Palmer, Jesse Law, and Dr. Leslie Dobson, thank you all for being with us.